attorney David Bricklin. Come down from Seattle this morning. His areas of practice is environmental land use, property damage, landslides, contaminated wells, and energy and facility siting law. That's his specialty. David has extensive litigation experience representing environmental groups, individuals, municipalities, and tribes in a wide variety of environmental, land use, and condemnation matters.
So my name is Dave Bricklin. I'm a lawyer from Seattle. Been practicing in the field of environmental and land use law for the last almost 30 years now, I guess. Mainly representing private property owners, neighborhood groups, community organizations who are on the short end of the stick, if you will, dealing with something that somebody's trying to do to their neighborhood or community or property rights. I was asked to respond to a number of questions that were formulated by some of you folks in advance, and I'll do that. One of those was a little bit about my background. Our law firm is a small law firm. It is the experience I've had has been representing, as was mentioned, municipalities, small neighborhood groups, large environmental organizations, a lot of cases involving coalitions of folks. Some of the cases that might be of particular interest to you that we've dealt with in the past, I represented a consortium of local governments, private property owners, and others who are fighting a proposal for an oil pipeline across the state of Washington from the Puget Sound area over to the Tri-Cities area, Olympic Pipeline. And that project ultimately was defeated. But it was a project similar to this in that it involved a lot of different property owners being impacted along the way, and it involved not only a legal struggle, but an organizational struggle, and public relations, and a political effort as well. A lot of different things coming together. Another case that may be of some interest to you is a case I worked on up in the Seattle area where the transit agency up there was proposing to, or is building a subway basically through Seattle, and they're tunneling under several hundred properties in Seattle, and they needed easements from each of those property owners to have the right to tunnel under their properties. Again, we worked with a consortium of those property owners. Sound Transit wanted to deal with each one-on-one. We were able to pull it together so that we formed a group. In numbers, there is strength. We were able to pool resources, and the group as a whole was able to retain not only a lawyer, but also other experts to provide information to the group that any one of those property owners by themselves would not have been able to afford. I was asked about efforts involving big federal agencies. We had a case a number of years ago now fighting a proposal by the U.S. Forest Service to put a big new ski area on Forest Service land up in Okanagan County. And that project involved a decade-long fight that took us to the U.S. Supreme Court and back down. And we eventually won that fight as well. So we're a small firm, but we're to be reckoned with, I think. And we would represent you well, I think, if you decide that you want that kind of assistance. The questions that were asked of me, I kind of broke into two categories. I would describe as one category is what can we do to influence where the project is located, if there is a project, if there is a power line, because that's actually one of the options. But anyway, what are our opportunities to influence the decision BPA makes? And the other category is, if BPA is coming this way, what are my rights as a landowner as I deal with them in transacting and negotiating an easement for them to come across my property? So let me deal with the first category of issues first. Explain to you what I think of as what your rights are in the BPA process, and what your opportunities are to influence the decision there. And in a case like this, I would say that in the end, the decision is primarily going to be a political issue, political decision by BPA. They, as a government agency, have condemnation authority. If they, in the end, want to build a power line in Route A versus B versus C, to a large extent, with some small limitations, they've got the right to make that decision and pay you your money if they're crossing your land. That's the federal government has that right under our Constitution to do that. But how they make that political decision can be greatly influenced by you. And it can be influenced by you in a lot of different ways. First and foremost, your ability to influence them is going to be a function of how well coordinated your efforts are. Any one of you will not have nearly the ability to influence them as a group of you will have. There are many different ways that you can influence them. There is through media efforts, public relations, there's efforts developing allies, whether it's school districts, large industrial forest landowners, other local agencies, a lot of and in government, there's state elected officials, federal elected officials, U.S. senators, governors, land commissioner. There are a lot of different ways to look at this in terms of putting together a coalition that is saying the same thing about where you want this route to go. And so a large part of your effort needs to be putting together that coalition, figuring out what the message is, and having your voice amplified by having a lot of other people, a lot of other institutions, a lot of other agencies, elected officials saying the same thing. BPA, in the end, is responsive to that collective voice. Any one of you by yourselves is not going to have that kind of an effect on BPA. It's also important to get good information. There needs to be a research component to this. Anybody can get up and talk about cancer risks, can talk about impacts to salmon, about the loss of views, but sort of talk is cheap, if you will. And it may make a good headline or a soundbite or a flashy web page, but in terms of influencing the decision, those headlines, those soundbites have to be backed up by good substantive information. And so if you care about the visual impact, if you care about cancer risk, if you care about the damage to salmon streams, whatever it is, you need to not just say that, you need to have something to back that up. And so a major part of the effort has to be collecting that information to explain why the route that's coming down through this way has various impacts that would not be occasioned by some other route. There's also on the table here a possibility of no power line at all. And that's, when I saw that first, frankly, I was a little skeptical. I was wondering, is this just BPA trying to put on a show that, yeah, we're giving consideration to a no-line alternative, and not something we're, if you dug around a little bit and find out that wasn't something they were really considering. But I did a little bit of looking into that. I talked with a friend of mine who does a lot of work in this line of work, and gives a lot of credence to what BPA is doing in that respect. The firm they've hired, 3E, is very well regarded as pushing the envelope on non-power line alternatives. And if BPA's interest was just doing window dressing, they probably would not have hired this firm. And this firm has come back and said, basically, there might be a way to do this without a power line, without new transmission lines. And BPA is now told to go take the next step and look at it further. As I said, I was at first skeptical of this. I don't, from the little bit of digging around I've done so far, I've kind of put skepticism on hold, and I think it's worthwhile pursuing that as a legitimate alternative and seeing if there's a way to make that no power line option work. BPA's process requires then, the federal law that BPA is operating under, requires BPA to look at all reasonable alternatives to the proposal. That's why they have a variety of different routes in front of you. That's why they have to look at this non-power line alternative as well. And the document that they create that documents their analysis of all these alternatives is called an environmental impact statement, an EIS. You may have heard of that either in this context or in others. And the EIS, the law requires the BPA to create the EIS in 2 steps. They first have to publish a draft EIS. And that draft document is circulated to the public, to state agencies, local agencies, federal agencies. Everybody gets to look at it, review it, and submit comments on it. And then the BPA takes all that information and prepares a final document. That environmental information is then one part of the information that the BPA uses in making a decision. Because while the environmental issues are an important part, it's not the only things that the BPA has to consider. They have to consider transmission issues, power reliability issues, fiscal responsibility, and a whole host of other things. So the environmental analysis is one part of it, but it's a very important part of it. And the reason we have a whole separate track where this environmental information is gathered is because historically agencies didn't pay any attention to these environmental issues. Yeah, they were looking at the dollars, and yeah, they were looking at the politics, but they weren't looking at the environmental issues. So the law was passed. You have to go through this formal process of looking at the environmental issues to make sure that's part of your decision making. Now, the draft EIS is due out this fall. That's still quite a ways away, 6-8 months from now. One of the questions was, is it reasonable to assume that a citizens group at this time could create a new alternative, not one of the ones on that BPA has been looking at, and get that inserted into the process? I would say, at least in the abstract, yes, that is possible. That is how the process is supposed to work. If there is another reasonable alternative out there, and that is put forward, BPA has an obligation to look at it. The key word in that sentence was reasonable. They don't have an obligation to look at alternatives that aren't reasonable. What's the definition of reasonable? Well, it's pretty fuzzy, isn't it? So BPA has a lot of discretion in deciding which alternatives are reasonable and which aren't. I understand there's an alternative been proposed further east than any of the ones that BPA is looking at. BPA will have to make a decision as to whether that's reasonable, taking into account cost, landowner interests in that area. There's a lot of public land out there, environmental considerations, and other things. So, in theory, yes, BPA may choose to add that. In reality, I don't know enough about that alternative. I don't know if BPA knows enough about it yet to know whether that's